So as we talk to Dr. Banteka about her work, you're going to be hearing stories of some pretty brutal police violence. And so if you are a person who is sensitive to that kind of material, you may not want to watch either the entire video or at least that part of this conversation. Hello, my name is Michael Hunter Schwartz, and I'm the Dean of the McGeorge School of Law. I'm here today with Dr. Nadia Banteka, one of McGeorge's newest faculty members and an expert on policing law. Professor Banteka joined the McGeorge faculty in fall 2021. She has authored a substantial and important body of scholarship on international law and policing law. Her articles have appeared in prestigious journals at Vanderbilt, Illinois, Columbia, Michigan, Virginia, and Seton Hall. She teaches criminal procedure, criminal law, and law and technology at McGeorge. Professor Banteka holds an LLM and a SJD from the University of Pennsylvania. Today, we're going to be talking with her about her most recent research, an article focusing on wrongful police violence, an article that argues in certain instances, such violence should be punished as torture. The article will be appearing in the UCLA Law Review. Professor Banteka, tell us about your argument.
Well, what the paper is trying to address is what I find is a loophole in the way our civil legal system, but also our criminal legal system address police brutality. And essentially the argument is that there are instances of police brutality that would be better suited being addressed in criminal court and being addressed through a specific specialized offense towards police officers. That is the crime of torture.
Wow. So how do other countries deal with this?
Well, what's interesting is the reason behind me embarking on this mission to address this issue is exactly what other countries do. So international law essentially regulates and prohibits the commission of torture by a public official. The international law does this through the International Convention Against Torture, which in Article 3 essentially prohibits torture committed by public officials and calls and essentially obliges member parties to criminalize the commission of torture committed by public official. So essentially every common law country has done so, that is party to the Convention Against Torture has done so. Canada has done so, Australia, New Zealand, the UK, and they specifically criminalize torture committed by public official, which essentially encapsulates police officers. The United States is a member party to the Torture Convention. The time when we ratified the convention was during the Reagan administration, and through that process in the Senate, the United States essentially declared some unique interpretations with regards to the provisions of the Torture Convention, essentially passed a federal statute that prohibits torture, which only has extraterritorial application. So in other words, if a United States citizen were to commit an act of torture outside of the United States, they could be prosecuted, but not within the United States. And we're unique in that. Every other state has, of the ones I mentioned, has virtually criminalized torture within and outside of their own boundaries. But I think that's done. Right, we can do that. I can just speak. All right. That's it. I think I answered the question. We've done it.
I think you did. So help us understand, how could the United States be a party to a treaty that requires us to criminalize public official torture and yet we don't?
That's an interesting question. So two ways. One is that we did pass this federal statute concerning extraterritorial application. The other way, and that was the answer of the administration at the time, and the answer the Senate gave to this was that we already, in our domestic legal system, we essentially have other legal avenues of addressing these instances. The legal avenues that were given through these interpretive declarations were that instances of police brutality are covered through all civil rights, constitutional amendments, particularly the Fourth Amendment and the Eighth Amendment, So that was one avenue. The primary avenue that was intended to address this, of course, what I argue in the article is that this is just a civil remedy, right? When you have constitutional violations, individuals who have suffered these violations have the possibility of redress through the civil legal system. However, the International Convention Against Torture specifically requires that member states address this through the criminal legal system. So it is an interesting legal gap in our domestic legal system that I'm hoping to cover. Of course, states don't have a direct obligation from the Convention Against Torture to implement this. However, what I do is I urge states to consider implementing this new offense as a way of addressing this loophole that we've created.
Do any states have statutes that might work for this that are existing now?
There are 2 states that have criminal torture statutes, though those statutes are not particularized to police officers. So they criminalize torture as committed by lay people or perhaps police officers, though no prosecutors in those states have used these statutes to charge officers, and that's California and Michigan. Those 2 statutes are a good start. I think that in California and in Michigan, alerting prosecutors as to the fact that they can now consider using the statutes when appropriate and when the elements are met to potentially charge officers is perhaps a first step, though I would urge those legislatures to consider adopting a particularized statute that addresses police officer conduct for many reasons, including that prosecutors will have an easier job filing charges against police officers who perform such conduct. But certainly California and Michigan could start there. I will say an interesting fact about the California statute is that it was enacted a year before one of what I call in the paper sort of cases that epitomize conduct that amounts to torture, and that was the Rodney King beating. So the criminal torture statute was adopted in California a year before the Rodney King incident happened, and yet prosecutors charged those police officers with assault, leading to 3 acquittals and a hung jury on those charges, and never considered that perhaps the incident could be better addressed through the elements of the torture statute that had just passed a year before.
Oh, sounds like they could have. How about some of the more recent examples like George Floyd of police brutality? Would the statute that you propose address the things like that?
Absolutely, and I talk about this in the paper. So I conceive of the instances in which the statute could have application as being sort of largely 2 scenarios. The instances that would fall into police violence in searches and seizures, and the instances that would be police violence in detention. So instances that are covered by the 4th Amendment and instances that are covered by the 8th Amendment in the civil rights context. Now, the George Floyd example is one that I discuss in the article, and it's interesting because it is one singular instance where we were able to get accountability for the officer involved, and it was unique in the fact that it caused a whole movement of Black Lives Matter that was pre-existing but erupted again due to the brutality that Mr. Floyd was faced with. And with the existence of a lot of evidence, and I would argue the support of the upheaval, the social upheaval that was caused, Derek Chauvin, the officer responsible, was eventually convicted. However, that instance is very singular. If you look at the data, in 2020, about 1% of the officers who are accused of police brutality, including police killings, were charged, let alone convicted. And the prosecutors in those cases, about 50% of those cases, the prosecutors knew who the officer was who had committed the criminal conduct. And yet, no charges were made against those individuals. So in the George Floyd case, we have a lot of video footage, which helps in making the case for it being torture. Of course, we had a murder of George Floyd, and that led to the prosecution of Derek Chauvin for homicide. But think of the more fortunate scenario where Mr. Floyd had come out of this alive. What could the prosecutor have done? Maybe bring charges for assault or battery for the same conduct, but say something changed at the end. Maybe the prosecutor would bring charges for assault or battery. Probably the prosecutor would not bring charges. And if the prosecutor had brought charges, would likely lead to the acquittal of the officer from a jury. Likely the officer would argue that he reasonably acted the way he did through the high level of discretionary standards that our existing criminal statutes provide. Now, that would have been a highly problematic outcome because the conduct would have been the same, just the outcome would have been different. So what I argue in the paper is that in such instances, when you look at the footage and you see the way that Derek Chauvin and the officers around him approached Mr. Floyd, the continuous violence for over 9 minutes of kneeling on Mr. Floyd, sarcastically and sadistically asking him to get up and get in the car as he's kneeling on him. There were bystanders who were essentially accusing at the moment Derek Chauvin and the other officers of enjoying this. And when you look at this, that to me matches what I call in the paper the affliction of cruel and extreme pain and suffering, which is the definition of torture.
Professor Banteka, can you give us some other examples of how the proposed torture statute might have a positive effect on changing police behavior?
Sure. Well, let me give you an example of a case in the detention context, moving away from the searches and seizure context. So an infamous case of continuous conducts that amounted to torture is the example of the known as reign of John Burge in Chicago and the Chicago Police Department. So John Burge was a commander in the Chicago Police Department for about 30 years, and unfortunately, after his departure, a lot of evidence came into the surface that indicated that John Burge and his officers had implemented several tactics that are clear-cut examples of torture. They had what was known as a box that was essentially a torture chamber, where they utilized means such as electrocuting individuals, tactics like one named dry submarino, where they put a plastic bag over a person's head and a gun in their mouth, imitating at once a Russian roulette and the feeling of suffocating, and many instances and many kinds of tactics that the Committee Against Torture, the organ responsible for assessing torture allegations under the International Convention Against Torture at an international level, has found to be essentially torture. So Illinois, I will say, is and has been a leader in discussions about criminalizing torture in the domestic context. However, they have not done so, and I think that they would be a primal example of a state legislature that could go ahead and implement the offense that I'm proposing in the paper.
It sounds like we need it. What do you see as the biggest hurdles to getting states to enact torture statutes against public officials?
I would say, like with most legislative efforts, political will. Look, I mean, every time we propose a statute that's trying to promote police accountability and deter police from committing acts of violence, there are many interests that are involved in that conversation, and state legislatures take those into account. So I think political will is the major one, but given the existing social movement, the social movement momentum, and the particular urgency that, as I discuss in the paper, that is prompted by the increasing police militarization. I think we urgently need a statute like this. And when I talk about police militarization, I'm referring to the fact that many police departments across the country are increasingly engaging with a culture that prioritizes addressing instances through violence as opposed to other means of more community-based policing. And that increased militarization and the culture of police departments, many scholars have argued, has the potential of causing more and more human rights violations, including more and more conducts that can amount to torture. So I think that legislatures passing this kind of a statute is imperative at this moment.
Thank you, Dr. Banteka.